Hello everyone, and welcome to our session today where we're going to talk about assessing risk in disputes. I'm Emily O'Neill, General Counsel for Deminor for the UK, and I'm joined by Michael Schafler and Michael Beeforth from Dentons in Toronto, and by Katherine Knight, who is the Vice President General Counsel of Mitsubishi Motors North America. I'll let my co-panelists introduce themselves as we go through, but just before we begin, a bit of housekeeping. On your screen, you should see a chat box. If you have any questions, just type them in there and we'll try to pick them up as we go through. The session's recorded, but no one else will be able to see your questions. So just to get started, I wanted to put this session together today as a helpful tool in how to assess risk in disputes and how to be able to communicate that internally within your business. So before joining Deminor last year, I was the Chief Counsel for IP and litigation for a listed company here in the UK, and I managed disputes across our global footprint. And I used the decision tree analysis that Michael will talk us through today as a way of putting more structure around my risk assessment rather than just relying on more of a gut feel analysis. So after Michael have covered the decision tree, I'll then go on to talk about building in the economic factors, and then Katherine will lay out how to lay the groundwork for risk analysis within business. So let me hand over to Michael for the start of today's session and to introduce themselves.
Mike, you want to go first or should I? I guess I will go. I'm Mike Beeforth. I'm a partner in Dentons' office in Toronto, Canada. I'm a litigator. I've been here for about a dozen years now, and I've worked very closely over the last few years with my partner, Mike Schafler, who is having some technical difficulties apparently, which we might need to rescue him from. You want to come to my office?
Can you hear me?
Yes.
I can't hear anybody else, but that's fine. Mike, give me a hand signal if you want me to get launched, if you can hear me at least.
We can hear you. So Mike and I, as we work through our technical difficulties, have use these risk analysis.
Okay, I'm being told to introduce myself, so I'll do that. I'm Mike Schafler. I'm a partner at Dentons in the Toronto office. I'm delighted to be here. This is the oddest presentation because I can't hear anybody else, but I'll see if we can get by. I've been with the firm for over 25 years, and Mike and I, about 15 years ago, decided that this was a really helpful tool to help clients understand risks in litigation even before and during, and to assist primarily with assessing settlement options when they're presented, and to optimize settlement positions during mediations or in settlement negotiations. So delighted to be here today and to share some of our thinking with you all. Perfect. So the question about what is risk analysis does come up a lot. You can see the slide there, but what this really boils down to, what I've said to people over the years, is consider this little hypothetical fact situation. A lawyer has just met with her client to discuss the merits of their case, and so the lawyer has gone back to the law firm to talk to their colleagues about the case, and the lawyer reports that I just had a really tough conversation with the client. You know, I don't really think they have a very good case. And one of the colleagues says, well, what did you tell the client? Well, I told her she had a 50-50 case. Meanwhile, the client has gone back to her office to discuss the merits of the case with her colleagues, and she's elated, and she reports to her colleagues that we have an awesome case and we're going to win. The client told me we had at least the lawyer told me we had at least a 50-50 chance of winning. So the lesson about this is that you have to be really specific, and you have to define your analyses very carefully when you embark on risk analysis, so that everybody understands what exactly you're talking about. And so historically, in the so-called good old days, instead of maybe even saying 50-50, lawyers would say, hey, you have a good chance, or you can see in all likelihood, or you have a strong case. But what does that really mean? And in today's age, we've learned that C-suites in particular, they want a little bit more than that. They don't want just the gut feeling. They want to understand numerically what are the risks. And so this is what risk analysis today looks like. It presents itself more scientifically. And before we go to the next slide, though, just be careful. The numbers that we're going to go through today depend on what goes into the analysis. So as it says on the slide, if you put garbage into the hopper, I can assure you that garbage will come out at the other end. So you have to be extremely careful. So if we can just turn to the next slide, please. So there are different ways to present this, and Mike and I are going to build up a case for you today, a hypothetical case that basically follows what you see on the left-hand side. There are, I'll just tell you, there are other ways to present this. There are Excel spreadsheets that you can use, that you can manipulate quickly during meetings when you want to change different assumptions. You can do the bar graph presentation that you see on the right, for example. But all of this boils down to eliminating the trust me, or you've got a great case, and replacing it with something a little bit more robust. And we'll have some words of caution at the end about what you do with all of this, but we'll walk you through this, and Mike will get us started.
So before we get there, a little bit more on how this tool is used and when. So the context that Mike and I have used it mostly for clients is for big class actions in the US for insurance companies, where there are large classes that can be broken into subclasses with like characteristics. And when, as Mike said, the C-suite is trying to figure out what their exposure is in order to facilitate settlement discussions. But you can use this tool at any point during the litigation process to enhance your or your external counsel's professional judgment, depending on which chair you're sitting in. It can be used as, in an early case assessment piece. It can be used at mediation. It can be used throughout for various strategy decisions. And as Mike said, the utility of the tool is going to be based in large part on the information you have at the time in terms of both your own case and its strengths and weaknesses, and the other side's case. And as the slide says, this can serve various purposes. It can help you with settlement offers, as we've done in the past. It can help you figure out the relative importance of the issues in the case, which you'll see when we go through the decision tree. And it also helps you to figure out what you're really going to have to focus on to convince your opponent or a mediator or a trier of fact as to what really matters. And when you're doing this, in addition to this is another word of caution, in addition to the facts of the case and the issues that you're dealing with, you also need to account for other hard and soft costs. So in jurisdictions where there is cost recovery in the event of success, such as in Canada, you're going to need to figure out what your legal fees are, not only what you've incurred and what you might incur down the road, but also what you would stand to recover if you're successful, or alternatively, what your exposure is to the other side if you're unsuccessful and you need to pick up part of their legal bill. You need to think about things like internal costs, what's your actual cost internally, but also what's the opportunity cost of having your employees traipse off to trial in the event that you need to try a case. And finally, what's the time value of your money? So all these factors matter. The other influencing factors on the slide, the admissibility and availability of your evidence, how your witnesses are going to do in the box, any interlocutory issues that you're dealing with through the case, who your judges to the extent you know that, and whether there are any changes in law. So these are all pieces of information that go into the exercise in coming out at the other end with an informed risk analysis and settlement position in your case. And as you see from this slide, all of these factors, you might end up with what your risk-adjusted value is of a case. In this case, 1.4 million. But when you factor in these softer factors, your legal costs, the time you're going to have to put into things, the haircut or the premium you're prepared to take in order to discount your risk, these all factor into a zone of negotiation that this risk analysis can help you arrive at in an informed manner. And you always need to think about what the other side is thinking, because they may well be doing the same exercise. So Mike is going to take us through the sample problem.
Thanks, Mike. So the situation is that we're dealing with a very well-paid former executive, it appears, who was being paid $10 million a year in salary and had $10 million in annual stock options. So he was let go and has sued for wrongful dismissal and a series of damages. And the defense, we act for the company, our defense is that there was a mandatory retirement policy. And the legal issues are that are being advanced by the former executive are, firstly, that he did not know of the policy, that in any event, the policy didn't apply to him as an executive. And then you'll see that even if it did apply, the legislation that allows such policies violates his constitutional rights. And then on the damages side, says he's entitled to 2 years of notice or damages. And the defense says no, if anything, you should be entitled only to 12 months. And if we advance to the next slide, please. So you can tell from that then that the claim is for $40 million. And so what's now happened, and why we're being brought in to talk about this, is that the plaintiff has just offered to settle the case for $15 million. And so the client has asked us to evaluate for them whether that particular offer is a reasonable one in the circumstances. And so we're going to now walk you through how we would go about building a decision tree for this. So from the legal issues, so the critical thing for this is that you're going to build a decision tree, and whether it looks like a graph or a chart, or if it's just a formulaic expression on a piece of paper, the principles are always the same. What you need to do is think your way through the legal issues and set up what the potential outcomes might be. We're going to show you this in more detail, but the most important thing, and where Mike and I have spent the most time when we get retained on these things, is we literally, at least before this pandemic, we would go into a boardroom and start scribbling things on huge scraps of paper. This obviously is a somewhat simplified problem to make the various points that we want to convey today, but there can be very complicated commercial disputes involving many different types of decisions that need to be undertaken. And for every situation that you come up with, for every legal issue that you identify, there has to be an A or a B decision, because we're then going to use those decisions or outcomes to assign probabilities. And once we've figured this all out in a string of decisions, the law of statistics informs us that you multiply those probabilities through to the end. And if people aren't familiar with statistics, it sounds a little unintuitive, but basically that you'll see that's how you set it up. And then once you've done all that, you've exercised your professional judgment, and we'll talk about that a little bit as well, what goes into that. You simply do the math and you're going to get a series of results which you then interpret. So Mike, can you set the stage for us on how we would go about identifying these issues?
Sure. So in this sample problem, Mike set out the arguments earlier, and so the legal issues are fairly straightforward, which is helpful when we're dealing with a sample. The questions are liability. Did the plaintiff know of and agree to the mandatory retirement policy? If he did not, did the policy apply to the executives? And in any event, is the policy lawful under the relevant legislation? And you also need to look at damages. So if there is liability, what are the damages question? And there are really two here. Is 1 year or 2 years the proper notice period? And will stock options make up a portion of this executive's damages? And so once you've identified those issues, you then need to define your outcomes. And as Mike said, generally these will be binary. Sometimes in a damages situation, you may have situations where you have 3 or 4 or 5 different outcomes based on what your expert evidence is or what your facts are or what have you. But generally speaking, and in this instance, we're dealing with binary issues. So the questions on the liability side are the plaintiff either knew and agreed to the policy or he didn't. And if the plaintiff knew and agreed, well, then you probably have a valid defense. If he did not, then you turn to the next question, whether the policy is applicable to him as an executive or not. And if it is applicable to him as an executive, the third question you look at is the policy lawful or unlawful? On the damages side, as I said, and we'll show you this in the decision tree in a couple of minutes, you've either got 12 or 24 months notice, and for each of those outcomes, you also need to determine stock options. So Mike will walk you through the liability piece in the decision tree as we go through it.
Okay, so and we can advance the slide, so we can, in the interest of time, we can just put the whole thing up. So what you see unfolding here in front of your eyes is the decision tree that follows the legal issues and the outcome based approach that we've alluded to already. So the first decision obviously is, do you settle or do you litigate? If you settle, you know there's a 100% certainty that you're going to pay $15 million. So that's what you're analyzing now, which is the counter decision to litigate. So you now want to basically calculate from a statistical point of view, based on all the information that you have, whether you can do better if you litigate or not. And if you can't do better, then you probably should settle. So litigate, as Mike said, there are 2 core issues at the outset. If the executive knew and agreed to the policy, well, then it's game over for the executive, and so you can see it's a win for the defense, for the company. And I'll come back to that in a moment, but that's a factual legal issue, which brings a few other considerations to the table. If the plaintiff didn't know, that would be good for the plaintiff, but not dispositive. And so you need to now go further. And so you're now going to set up sub decisions, which are always going to be either or. So if the plaintiff didn't know and the policy did not apply to executives, then the plaintiff will obviously be successful, and it says here loses in the right-hand column. That's from the employer's perspective, of course. On the other hand, it could be that it's established that the policy applied to everyone on its face, which would be, again, that would be good for the employer, but not dispositive, because you still have to go through the question then whether the policy is constitutional or lawful or not. And so you see again the 2 decision outcomes. So this is the framework that you've implemented based on the factual and legal issues that you've identified. And this is the boardroom exercise that I mentioned earlier that Mike and I would go through on every case, because this is what's going to inform your analysis. Then what you do, if you can go to the next slide, please, you're going to apply your professional judgment to this. And here's where the garbage in, garbage out that I mentioned earlier is extremely important. You'll see in here that probabilities have been assigned. So in this particular example, it's been determined that there is only a 20% chance, or 0.2, as you can see, that the plaintiff knew and accepted that this policy would apply to him. And I don't know if we've lost Katherine or not. In any event, I'll continue. And of course, if you plug in 20% or 0.2, and this is always the hardest thing for people who are new at this to get their mind around, the top decision and the bottom decision, plaintiff knew and agreed, plaintiff did not know. Those two must always equal 100. If they don't add up to 100, you've done something wrong. Each column, in fact, has to add up to 100. So if there's a 20% chance that the plaintiff knew and agreed, there must be an 80% chance that the plaintiff didn't know and didn't agree. And then you go to the next piece of the analysis, whether the policy applied or did not apply. And so here, the chances are a little bit more balanced. 60% that it did not apply, 40% that it did apply. Again, 60-40. And then finally, whether the policy was lawful or unlawful. And what you then do with this in a moment, well, I'll show you the math, but how do you get to 20%? How do you get to 80%? How do you get to 60%? This is where you have to, as I said, use your professional judgment. You have to evaluate the evidence. That's obvious. That sounds pretty plain and obvious, actually, but it's not quite that simple. Evaluating the evidence includes such things as, are we going to be able to present the evidence at trial if this doesn't settle? Are people still with the organization? And this is part of enterprise risk that we'll talk about a little later when Katherine shares her thoughts with us. But too often it happens in the litigation process where the lawyers have mapped out the most wonderful defense or claim, and then the time comes to prove it, and oh, well, we let so-and-so go 2 years ago, but nobody bothered to tell the legal team. And so that affects your legal chances, obviously. The other thing is whether even if the people are there, are they good witnesses? Are they going to be credible? So these are all elements that go into the evaluation of what those numbers, in your professional opinion, should be. If we go to the next slide, you can then see how this works. So in terms of what we're looking at is, it turns out there's a 40% chance overall on liability that the case will be successful. So if you look at the various arithmetics here, you're going to see, so 20% chance that the plaintiff knew and the policy applied. So that means there's a 20% chance, based on our analysis, that the employer is going to win. Okay. Now, if you litigate on the second half of the decision tree, it becomes a little bit more complex. So if the plaintiff didn't know, we said we start off with there's an 80% chance, 0.8. And then if we look at whether the policy did not apply, there's a 0.6% chance. So what you now do to get to the 48% is the plaintiff didn't know, 0.8, times the policy didn't apply, 0.6. 0.8 times 0.6 is 0.48, or 48%. So there's a 48% chance baked into that the employer is going to lose on that part of the decision tree. Now, the bottom half of the analysis. If the plaintiff didn't know, but the policy applied on its face to everybody, 0.8 times 0.4 is 0.32. And then you have to add one more layer to it, which is whether the policy was lawful or not, times 0.6. When you do that math, you get to 0.192 or 19.2%, which means the employer in this case wins, because we're looking at this from our perspective, as I said. And conversely, if the policy is unlawful, employer loses. Again, 0.8 times 0.4 times 0.4 is 0.128 or 12.8%. And to confirm that you've done this correctly, when you add up the 20 and the 48 and the 19.2 and the 12.8, it comes to 100. And then, so basically what this means is that you have a 60% chance of losing this case from the employer's perspective. So what do we take from this in terms of damages, Mike?
Well, then you need to do a second decision tree with respect to your damages and apply the likelihood of success to your various outcomes in the event you're unsuccessful. So again, in the interest of time, I'll just flip right through this. You already know that if you win, you're not paying anything. And we've previously seen that we think, based on our analysis of the liability case, you've got a 40% chance of coming out of this and winning at trial. If you lose, you then need to look at what the outcome is going to be from a damages perspective. And again, the two questions are, is it 1 year's notice or 2, which have damages tags of 10 and 20 million respectively. And then for each of those notice periods, do stock options form part of the damages award? And that will tack on an additional $10 million if ultimately the plaintiff is able to determine that is part of his severance package. And so again, you would do the same thing that Mike took you through a moment ago. You would look at each of these decision points on their own and evaluate them out of 100%. Now, we've already done the win versus lose analysis. That's approximately 40-60. And then we've determined that it's slightly more likely that a 2-year notice period will be determined. And at this point, we think that it's an open case as to whether stock options will form part of the damages award. And so we've attributed a 50-50 likelihood to that. So how do you turn all of this into numbers? Well, you multiply through your analysis here and say, okay, the outcome here is going to be a $10 million damages award if it's a 1-year notice period and no stock options. And we think that's a 60% chance multiplied by a 40% chance multiplied by 50 to arrive at 12%. And we do that through each step of the analysis. And again, you look at the end to make sure that your various end outcomes all add up to 100%. And here we've got a 40% chance that we win entirely, a 60% chance that we lose, and then 4 options arising out of that, each of which have their own statistical probability of an outcome. And to turn this into an actual number that you can work with, you do the math through and you multiply 10 million by 12%, 20 million by 12%, 20 million by 18%, and 40 million by 18%. You add all of that up and you come out to an expected value of the case, if you do the math, of $14.4 million. And we are dealing with a $15 million settlement offer. And so that's probably right around in the range of reasonableness from a risk-adjusted perspective. Now, one thing that we need to keep in mind is that if you ever go to trial on this, no judge is going to award $14.4 million. They're going to award 10, or they're going to award 20, or they're going to award 40. And so this number, and it's important for your business partners to understand this number is not the outcome that you're going to get if you don't settle and go to trial. This is based on all of the information we have right now, the risk-adjusted value of this case to help you determine whether or not to resolve this case for the settlement offer that has been proffered. And in the interest of time, we won't go through all the various soft factors that we discussed, but when you're in the boardroom and when you're talking about whether to accept this, you need to think about those witness questions, those evidence questions, all the soft things, your costs, your cost exposure that will help you determine what your settlement range is going to be. And I know that was fairly quick, and we can answer questions at the end. Mike, unless you have any other parting thoughts, we'll pass this over to Emily.
No, let's save it for Q&A because we're running a little tight against time. So thank you all.
So thank you, Michael and Michael. Hopefully you should now see my slides. So we've gone through the decision tree analysis, and we've looked at the legal risk, and we've looked at the probability weighted outcome based on the legal risk. So from the funding point of view, we now need to build in the economic factors. So we need to think about all the key financial elements of the claim. So we need to think about the cash out and the cash in. And why are we doing this? We want to really work out whether it is worthwhile to bring the case. So the purpose is to work out whether the probability weighted net present value of the cash in is greater than the probability weighted net present value of the cash out. So starting from the beginning, cash out, what is this? So this is your cost. So your court fees, your legal fees. If you're in a jurisdiction where there is an adverse party cost award, your insurance for that, your cost of capital, other fees. What's the cash in? So in this situation, we're just going to think a very simplified example. So from a business perspective, there may be other benefits to an action other than the cash in, but here we're going to look at the potential damages, the legal interest, and the award of costs on a court win. Then we need to look at the likelihood of these different factors and also the time. It's very important. So net present value, we want to think about the time value of money. So you can visualize this by thinking about having some money now and how much that money is worth and what that could buy you now versus what that could buy you in, say, 4 years' time. So you can think about, buying a house now with your money and buying a house in a few years' time. You may not be able to afford as much. Or you can visualize it from a business perspective. Having the money now means that you can invest that in your business and make more money. If you get the same value of money later, then you've lost that opportunity. So it's worth less to you. So visualizing net present value. So we have the claim value from Michael and Michael's presentation of 40 million. We're going to stick with the same example, but because we're a funder, we're going to be looking from the plaintiff side, and we're going to stick with the same example even though we don't fund employment claims. But the claim value 40 million, and then you come down once you've done the calculations to a net present value of 10.7 million, and we'll step through that. But it means that if there's a settlement offer of 15 million, you should take it. So what are we going to do? We're going to take into account various things. So we're going to look at the likelihood of settlement and when that's going to happen. We're going to look at time, the time to a court decision. We're going to look at our legal budget, and we're going to take into account legal interest and the cost of capital. So we've got our case scenario. We've got a 60-40 chance of winning. Now we're the plaintiff. And we're going to look at a jurisdiction where there's 4 years to trial. We're going to say there's the 20% chance of settlement. So from a funding point of view, we always look at settlement and court as possible different outcomes in the same scenario. And we're going to say there's a 20% chance of settling in this example. And that's going to happen at year 3 after disclosure, maybe summary judgment. So overall, we're looking at, from the probability point of view, an 80% court outcome, so that's court win or lose is 80%, and a 20% settlement outcome. So how does that look? We'll split that down. So we have our court win, our court lose, both at 4 years, settlement at 3 years. We'll split down the probability. So we have 80% for our court outcome, and the 60-40 splits down to court win of 58%, court lose is 22%, and settlement at 20%. We're also going to include litigation costs. So our budget for this case is 2.4 million through to trial. Settlement's going to occur earlier, so we're looking at slightly less at 1.96 million. We've got our probability weighted outcome of 14.4 million. And when we take into account the court versus settlement probabilities, we're going to come to a probability weighted outcome for the court of 11.52 in the win situation, lose will be 0, and then settlement will be 3 million. So 20% times 15, 3 million, 58 times 14.4, 11.52 million. So overall, our probability weighted outcome across our court win, court lose, and settlement is now 14.52. And we also need to take into account the length of the case. And this is why in funding, when we're asking about a case, we're very much interested in how long is it going to take, because that all builds into the figures that we need to calculate. So here, we're going to take 80% of the 4 years, 20% of 3 years, and we come out with a weighted average length of the case of 3.8 years. So next part of our calculation, we need to add in interest, and we need to take off our cost of capital. So in this jurisdiction, we have 8% legal interest, and that's over 3.8 years. So we're going to add the interest to our probability weighted claim value, and we're going to come out at 18.93 million. We're then going to take off our cost of capital. So every business has a cost of capital. It's the cost of raising money. So that could be a debt and equity combination. Here we've got 11% for this particular business as the cost of capital, and calculating that over 3.8 years gives 6.2 million. So we'll take that off our 18.93 million, which gives us a net present value of our litigation before litigation costs are taken into account of 12.73 million. We then come to our legal budget, and we're going to look at our budget across the court situation and across the settlement situation. So our court budget is split over 4 years of the full budget, 2.4 million, and we divide down the approximate budget by year, calculate the net present value of that, do the same for settlement. So here, year 3, we've got a bit more in the budget than we have in year 3 for the court because we've got some negotiation costs. So we've built that in, and we've got net present value for a settlement in terms of the legal budget. So taking 20% of our settlement budget, 80% of our court budget, we get a probability weighted net present value of our legal budget of 2 million. So we take that off our litigation cost, and we come out as a net present value of the claim at 10.7 million. So we're now at 27% of the nominal value of the claim. So this is just a summary slide to show what we've gone through, because I appreciate we went through that very quickly. So to recap, we started off with our nominal claim value of 40 million. We worked out, or Michael and Michael worked out, the probability weighted value of the claim, 14.5 million. We have add on our legal interest over 3.8 years. And we have the probability weighted value of the claim, including interest. We take off our cost of capital at 11%, and then we get our net present value before litigation cost. We take off our litigation cost, and we get to the 10.7 million. And so if we're looking at a settlement offer at year 3 at 15 million, or we think that the net present value at the end, taking into account all outcomes, is 10.7 million, then the settlement seems like a good offer. But I think when you're talking internally within a business, and the exec are thinking this is a 40 million claim, and you're looking at a 15 million offer, it's really being able to set that in context for them, just to say, no, it is less than half, but actually, once we've taken into account the likelihood of success, our cost and time, this is a good offer. So I'm now going to hand over to Katherine.
Okay, great. Hi, everybody. I'm Katherine Knight. I am the General Counsel for Mitsubishi Motors North America. I am located in rural Tennessee, so it's lovely to be talking to so many folks from all over the world. So I am a person who has to engage in the litigation risk analysis on a fairly frequent basis, probably weekly, if not sometimes daily, in the course and scope of my work. And I've been doing that for a long time. But when I became involved significantly in risk management is when I came to realize that there is actually a really good way of looking at all of the underlying information that goes into your risk analysis that you may not be thinking of as legal counsel. And I say that both for those of you who are in-house and for external legal counsel in thinking about risk management. We were talking about garbage in and garbage out. And so the question is, how can you make sure, especially when you're talking about some of the soft costs and assessment of uncertainties that impact your risk analysis. How can you figure out what those are and have the best base of knowledge with which to do that? Can we advance the slide? Next one, please. Great. So there are a number of things that are going to impact your risk analysis. Some of these were presented in the prior presentation. Your internal opportunity costs, time value of money. We just talked about how long is your litigation going to take. Availability and admissibility of evidence. So are you following your retention policies? What does your data security look like? All of these things can impact your analysis. And sometimes even softer issues and assessments of uncertainties. What is the performances? What is the performance of your witnesses going to look like? And there are a lot of others that aren't even specifically legal. Are your policies updated? Will there be unseen impacts on your business strategy if this litigation goes forward? And does that need to be part of your risk analysis? Is there danger of a plant closure months from now that's going to impact whether or not your star witness is even with the company any longer? Or maybe your star witness is also going to be involved in a project that is one of the most important strategic projects for your company for the next 2 years, and that person simply cannot be bothered with the stress and the time that it takes to be the star witness in a huge lawsuit. So then you have to understand, how does that impact our risk analysis, or do we need to find a different witness, and what does that look like? So there are a number of things that, again, are not specifically legal that can impact your risk analysis. And again, it's about garbage in, garbage out. So what I'm talking about is not necessarily in the realm of risk management. That would be another 8-hour, that'd be an 8-hour day to talk about just litigation risk management. What I'm really talking about is just how to arm yourself with that knowledge. And I will tell you too, that the more knowledge you have about the company's risks, the more credibility you will build with the C-suite. If you know, for example, that the person who would be your star witness also happens to be the person who's involved in this 2-year strategic project or the strategic planning that you have going on, the C-suite is going to understand that you really have solid knowledge and understanding of the business, and that just goes a long way into developing your credibility with them when you also have to tell them, look, the probability of a good outcome is fairly low. Here's why that is. If they know and understand that at the top of your mind are the company's business objectives and strategies, then they're more likely to believe that you're keeping that in mind when you're engaging in your risk analysis. So the challenge that we have as lawyers, and especially external counsel, because you're not connected with business people for your client on a day-to-day basis, is how can we do that? How can we be prepared early and often to be able to engage in the risk analysis? How can we be able to engage in the risk analysis when frequently you might have a few days to put this together and make a presentation? And so there's just a tremendous amount of information that you're trying to find out in a very short period of time. How can you do that? What makes sense for you? So the practical reality is you've got to find some way to understand your business. And for me, I thought that I was very good at litigation risk management. I thought I was very good at legal risk management up until my last job. When I showed up on day one as general counsel of my prior company, they said, oh, by the way, you're also the chief risk officer. And so that threw me into a world of understanding not only traditional risk management and litigation risk management, but also risk management as it related purely to the business. Next slide, please. So what I will tell you is that there is a concept of enterprise risk management that if you don't know about it and you're not involved in it, you should be. So enterprise risk management is not a specifically legal exercise. It is not about litigation risk management or legal risk management generally. So why should you care? You should care because if somebody at your company is doing enterprise risk management, if they're doing this assessment and analysis, then you really need to connect with that person and try to gain as much knowledge from them as possible, because you really have an opportunity to learn about the peripheral risks that could impact your case that you wouldn't necessarily know about just from the myopic viewpoint of your legal risk. So enterprise risk management, again, another thing that I could probably spend 8 hours talking about, I'm going to try to spend 5 minutes on it, is it's a way of assessing risk that goes beyond traditional risk management. So the known risks that are insurable, safety claims, things of that nature. It looks at all risk horizontally and vertically across the organization. And what that assessment does is it assesses all of the risks that exist within the company that could impact the company's strategic objectives and business priorities. So again, this is not a purely legal assessment. A lot of it has to do with PR risk, reputational risk, financial risk, human resources risk. But if you know all of that information, and if you're hooked in with that, then you're in a much better position to understand your legal risk. So often what comes out of the enterprise risk management process is a prioritization of risks that the company needs to mitigate. And again, not all of those risks are going to be legal. So if you're not hyper aware of what's going on with the company's risk management processes, you may not even be aware of what these priority risks are because they may not have a legal component. But when your company is sued, these other risks, these business risks, these strategic risks could potentially have a significant impact on your risk analysis and on ultimately what settlement of that litigation or what moving forward with that litigation looks like. Next slide, please. So what is it? What exactly does it do? It seeks to find both the macro risks and micro risks facing the business. And if you have a well-developed process for this at your company, it's going to be this beautifully laid out matrix that sort of qualifies and quantifies what these risks are and assesses probabilities. So if somebody is already doing this, it will be really easy for you as counsel to be able to talk to the person who's doing it. It may be the chief compliance officer, chief risk officer, whoever's responsible for business continuity, and really deep dive into an overall picture of business risk. Next slide, please. Hopefully, if somebody at your company is doing this, they are involving legal in it, at least with respect to litigation risks and legal risks, because of course, those are a huge component of the overall enterprise risk management of the company, but they are not the legal risks are not the only priority that you have. So what a good enterprise risk management program looks like is an assessment truly across the company in every single department, and looking also for cross-functional risks, which can sometimes be very hard to identify if each business department is looking at its own risk myopically. So hopefully your risk manager is looking cross-functionally to figure out some of these much bigger risks that are facing the company. Again, hopefully somebody is already doing this within your company, but if not, I have become completely self-taught in how to do enterprise risk management and have been doing it now at 2 different companies. It's fairly easy to learn. It's not rocket science. It's time consuming, which again is why I suggest that you don't, as an attorney, have to be significantly involved in it, but you do need to be talking to the person who is managing it and understanding how they're developing out that risk profile, because those things can be affecting you. And again, if you are external counsel, one of the biggest challenges you have is understanding the business of your client because you're not embedded in it every day. So I would strongly suggest to you, if you are external counsel, connect with the in-house counsel who's your client and say, hey, can I talk to the chief compliance officer? Can I talk to the risk management people? Can I connect with them and just have a better understanding of your business as a whole? Because again, what is this about? It's about making sure you don't have garbage in, garbage out. The more holistically you understand the business and what risks you may be facing, especially in year 1, year 2, year 3 of your litigation as you go down the road, the better your outcome is going to be. And it can be, like I said, very, very hard to discern those things when you've got 5 days to put together a risk analysis before you're going in front of the C-suite. Next slide, please. Whoops, that went one too far. Back one. There you go. So just very quickly, a few tips that aren't specifically related to ERM. And again, these are not about risk management and mitigation, which is completely lengthier subject, but just some tips that if you're thinking about them will help you have that base knowledge that will help you not have that garbage in. So again, separate from risk management practices, you need to be partnering with your business departments anywhere litigation may be a risk. You need to understand their business, what their challenges are, and what they're doing. It's very time consuming, but also critically important. And quite frankly, that's why if somebody's doing enterprise risk management, hooking in with them can actually save you a lot of time if your company has a pretty robust process. If available in your jurisdiction, especially in-house, creating attorney-client privilege ahead of time. This is what I'm always talking to my business partners about, is that, you know, I'm not here to be a roadblock to your business. I'm here to protect you. So if we're having risk discussions in a privileged manner on the front end, then we have the opportunity to protect the privilege of documents. We have the opportunity to protect the privilege of communications between us and communications about some of these more risky issues that on the back end, you know, we no longer have that opportunity and it's discoverable. I realize that opportunity is not available in every jurisdiction in the United States. It certainly is. And so I try to use that often. Better documentation. This is what I tell people all the time. Create your trial exhibits in advance. Again, sometimes your business partners will be reluctant to involve you because they're like, oh, it takes me a week to get something back from you, blah, blah, blah. What I say is, okay, I understand that and I don't want to slow you down. However, we're creating our trial exhibit in advance. You know, we know what we want to say. We have the opportunity to make sure that it's consistent with other types of communication of this sort across the company. So, you know, let's be smart and proactive. And how does that help you when you're engaging in your risk analysis? You already know what your documents look like. You know what's going to be privileged. You know what's not privileged. You know your documents look good, and you don't have to spend an entire week just poring over documentation to determine whether or not there's a smoking gun. You know, hopefully you already know that there's not, you know, fingers crossed. Understanding each department's standard operating procedures and their adherence to them. A lot of times this is not part of your legal risk analysis if it doesn't specifically have to do with a policy or compliance policy. If it's just your department's standard operating procedure, you may not know whether or not they're complying with it, and it may not be a legal issue, but you know, you have that SOP requested in discovery, and then you have that manager in a deposition say, well, we're not following our SOP. How does that make your case fall apart? Even if, again, if this is not necessarily a legal analysis, if you understand what the business is doing, whether or not you have the opportunity to influence them to change it, which is a separate topic, at least you have that knowledge, and that's better knowledge into your risk analysis. Understanding their contractual relationships, where your third-party created risks comes from, is critically important. Again, separate and apart from mitigating that risk, just understanding who those parties are is critically important and what they're all about. And then again, my last tip for you is to look globally. So for example, if you're a company that has antitrust risk, partner with procurement in other jurisdictions, not just your own. Partner with design and engineering in other jurisdictions if product liability is a risk for you. Look a lot more broadly for business partners that could potentially tell you about your litigation risk in the jurisdiction where you're located. Because a lot of times those issues can be global. And it may not be enough to partner with your counterparts in legal in those other jurisdictions, because those other jurisdictions' legal departments may have different functions than the way that your legal department functions. They may not have the opportunity to create attorney-client privilege. They may not be managing litigation. It may be completely external. So you may have to go past legal in another jurisdiction and actually go to those business partners. And then finally, I'll just leave you with a question, which could also be the subject of another 8-hour seminar. You need to know where your data is. Where's your data? That will help you significantly when you're engaging in that risk analysis. So that's about it's very quick tips on laying the groundwork for your risk analysis as counsel. So thank you very much.
Thanks very much, Katherine. I think that was very useful, and I'm smiling because all of those things I think came up for me when I was in-house. So yeah, I think we've had a few questions come in. So let me just go to the chat box and we'll see if we can answer a couple of those. We've got a couple of minutes left. So the first question was, how do you discount the risk of imperfect information on the side of the claimant? The claimant will have a subconscious bias to forget critical information, i.e. that one email that they sent. Michael, would you like to start on that one?
Sure, really quickly. As we said at the outset, the utility of this approach is going to depend on the stage you're at and the information you have. So if you've had discovery, or if you've conducted depositions, or whatever the discovery process is in your jurisdiction, that information will be known. If you've exchanged documents but you haven't yet done depositions, well, you have some information, and that allows you to pinpoint the issues that are going to be important for you to emphasize to the other side. If there is that smoking gun, as Katherine said, on the other side of the case, you know that you got to stick to that, and you know you got to really put it forward in however you're either putting out an offer to sell or responding to it. If you're in a mediation, you obviously have the ability to do that in a brief and in submissions, but part of the process will allow you to highlight those facts if you know them, and be able to highlight them for the other side. If you don't know them, if you're not at that stage yet, there's not a whole lot you can do except to anticipate that you don't know what you don't know, and build in perhaps a larger zone of negotiation. And it's also important, I think, to keep in mind to do that from your side as well. So if you don't have a client that's been as well protected as Katherine's, and you do have some SOPs that haven't been followed, or you do have some data that's flown out into ether, your client needs to know about that too, so that they can properly assess their risk position.
I think from the funding side, it's quite difficult, because often if we're coming in at the start of a case, then the information is imperfect. So disclosure or discovery may not already have been done. So from our side, it's really asking the questions to the client to work out, how sophisticated they are, and then build that into our probability analysis. So just understanding a little bit about how the client works and their business, to be able to really take that into account. But again, you don't know what you don't know, and there's always a risk in litigation. I think the second question, how do you apply this quantitative approach to portfolio management or risk management at the portfolio level? Michael?
Yeah, I saw that, and it reminded me at first instance of the analysis that we've done in the context of class actions, because you really, if I understand the question correctly, what you're looking at is a set of common occurrences and common themes and common exposures, factually and legally, and this is where I mentioned earlier we've used other more sophisticated methods to capture the information, and in that case we've done Excel spreadsheeting, and we've tied together various cases to create common risk profiles. So anyway, the short answer is yes. Remember, the basic concept is you take your decisions and you build your decision tree out based on those decisions. So you can apply it to any scenario, and that would include trade secrets, which was another question that I saw in the here. We, for us, that's the Anton Pillar type of context, where essentially the war is settled very early on, because you're bringing an injunction to stop the prohibited conduct and to get information that's been taken away. Usually you do it ex parte or without notice. But let's just say you're continuing with the litigation. It would be like any other litigation. You run the analysis. Was the information confidential? Was it protected? Was there a contract? Was it not confidential? Was the contract breached, not breached? Were there fiduciary implications? All the usual suspects would pop up. So again, you can do this in any context, frankly.
Thanks, Michael.
I'll just jump in very quickly to add to that because we have to analyze a lot of portfolio issues globally. Often what we do is we look at the jurisdictions that we think have the most risk. We sort of lay them out exactly as Michael suggested and try to quantify them individually, and then sort of try to rank them with respect to where the most risk exists and where we need to pay the most attention, while simultaneously not ignoring other jurisdictions where the risk exists. Often that risk, because of our very strange way of trying cases, is the United States. So I get to be the lucky person who manages the biggest risks, but it does often just involve a sort of a weighing, which is an imperfect way to do it. But where do we think that we have the most risk? What is the percentage? Kind of if you look at your global risk as a pie. How much risk, how much of that risk involves the United States, how much of that risk involves Japan, and we kind of divide it up that way.
Great, thank you, Katherine, and thank you, Michael and Michael. I think we've run out of time. Thanks everyone for attending. One last question was, will we share the slides? They will come round to you, and the recording will be available to you as well. So I hope you've enjoyed today. Please send through any questions by email to any of the panelists. You can find them all on LinkedIn. And thank you for joining.
Thank you, everybody.
Thanks, everybody.